Hey guys, welcome to my legal classes. Today I am going to start a new series on the Transfer of Properties Act 1882. Please subscribe my channel because I'll be keep doing series of lecture on this particular act. This act is quite lengthy, so I am not going to try to cover this act in one presentation. I am trying to make each concept clear so that by going through my presentation, you need not to prepare any further on that particular chapter. So whenever you feel you need notes, just take a screenshot so that you have your notes ready. Let's move on with the Transfer of Properties Act. Introduction. As the name itself is suggesting, this act came in the year 1882. The date of effect was 1st July 1882. The final draft was submitted by Sir Charles Turner, Sir Raymond West, Mr. Whiteley Stokes. You hear all the British names because this came during the British rule. They submitted this report to the Third Law Commission. I repeat the names: Charles Turner, Raymond West, both are having Sir, and then Mr. Whiteley Stokes. This act is not an independent act. This is being referred with many other acts. So when you are studying the Transfer of Properties Act, you need to have awareness on few other acts so that you can understand it easily. They are the Succession Act 1956, the Contract Act 1872, the Sales of Goods Act 1930. Now, what does Succession Act deals with? Succession Act deals with the property succession by testamentary or intestate. We all know the meaning of testamentary, where a person transfers or a person gives succession of his property to the next by the form of will. If any person die without a will, then his property becomes intestate, and based on the Succession Act, the owner will be decided or successor will be decided under the provisions of Succession Act 1956. Contract Act 1872 basically deals with agreement with legal obligation. We all know what is agreement. When there is an offer and acceptance, we call them as agreement, and when you have legal obligation on the same, that becomes contract, which is taken care by Contract Act 1872. The third one is Sales of Goods Act, which came in the year 1930. It is not that the act was not available earlier to 1930. It was part of Contract Act till then, but then it was felt Contract Act was too lengthy, so they have separated Sales of Goods Act from the Contract Act. So the Sales of Goods Act became independent in the year 1930, and this mostly deals with movable property. Now, Transfer of Properties Act, which came in the year 1882, this majorly deals with immovable property. I'm not saying it's absolutely dealing with immovable property because there are exceptions. I am dealing with those exceptions in my next slide. Hope this slide is very clear. When you are studying Transfer of Property Act, it is must that you should be aware on Succession Act 1956, the Contract Act 1872, Sales of Goods Act 1930, so that the concepts will be clarified more easily. Taking you to further slides. Scope and application of Transfer of Properties Act. The Transfer of Properties Act is applicable in India. Now, when we are saying the law is applicable in India, there are laws which are covering the Indians who are living outside India also, and their conduct outside India also covered by few of the acts. One of the example is Indian Penal Code 1860, where an Indian doing a crime outside India and if that is crime as per the Indian Penal Code, then he can be punished in India. But when it comes to Transfer of Properties Act, any transfer, any property transferred outside India will not be covered under this act. So that will not come under the scope of this act. This is covering only the transactions happened within India only. The second major thing or scope of this act is this is applicable only when it happens between two living people. Now, if you study Succession Act, we have something called interstate, where a person is died, but on the basis of the hierarchy, the next person get the succession. But here in this act, Transfer of Property Act, there is no possibility of having a transfer of property with the dead person. It is not available. So it should be between two living people. The third major thing that one should observe is transfer of properties between parties only. No forfeiture or insolvency or auction conducted by the government for an individual property will be considered as Transfer of Property Act, because those were governed by government rules for some crimes or debts or situation. So that is not voluntary transfer of property, it is by force happening, so that will not be considered as transfer of property. The Transfer of Properties Act mostly deals with immovable property. We have to say mostly because there are exceptions. Section 5 to section 37 are dealing with immovable property, so we cannot say Transfer of Properties Act is completely dealing with immovable property. It is also dealing with movable property, which is covered from section 5 to section 37. Now when I say sections, you will get a question that there are how many how many sections or how many chapters. You'll get all that questions. Don't worry, I am clarifying that in my future slides. This presentation will help you to understand the structure of Transfer of Property Act, the scope which I am already discussing, which are the other connected acts, and I am giving three major definitions in my first session, which is covered under chapter 1 section 3. So this much you will study when you complete this video, and minimum 20 marks question will come from this chapter. So it's very important that you follow this lecture very closely. Coming to the scope, chapter 2, that is section 5 to section 53A and section 129 relating to gifts is not applicable to Mohammedan law. This is one more interesting fact about Transfer of Property Act. We have studied many other laws where we have said it is applicable to all Indians living in India, living outside India, and there are acts where we said this is applicable to whole India except for Jammu and Kashmir, and then we have told this is applicable to all Hindus of India. Then we have laws which is applicable for all Islam or Muslims in India. Then we have laws for Christians, Persians. So we have different laws based on religion also. But here is a law where one particular chapter and one section is not applicable to Muslim, Mohammedan law. Rest of the things are applicable to everyone, but this particular portion, that is section 5 to 53A and section 129 which deals with gifts, is not applicable to Mohammedan law. So remember these 5 major scope and application of the act. This is applicable within India only. Transfer of property can happen between two living people only. Transfer of properties between parties only, but not legal like insolvency, auction, etc. The act mostly deals with immovable property, but there are exceptions. There are immovable properties also from section 5 to section 37. Then the chapter 2 which deals from section 5 to 53A and section 129 which deals with gifts are not applicable to Mohammedan law. Hope that is clear. Let's move on to the next slide. Now I am bringing to applicability. You are seeing too much colors in this slide. I kept red color for which the act doesn't apply and green color for which the act apply. Now, for which the act doesn't apply: for inheritance, insolvency, forfeiture is legal taking of someone's property, then sale of execution of decree by will. These things are not covered under the Transfer of Property Act. I repeat: inheritance, insolvency, forfeiture, sales of execution of decree and by will. Now, what is applicable under Transfer of Properties Act? Sale, mortgage, gift, exchange and charge. SMGEC. Sale, mortgage, gift, exchange and charge are covered under Transfer of Properties Act. Hope that clarifies. Let us move on with the next slide. There are 8 chapters in Transfer of Properties Act. I will explain all the 8 chapters very quickly so that you know the structure of this act. The chapter 1 deals with preliminary, which I am covering in this session itself. In chapter 1, where 1 to 4 sections are covered, the section number 3, the definitions, is very important. That itself is quite a big chapter, and I have covered that in this session. See, when you say Transfer of Properties Act, there are 8 chapters and there are total of 137 sections. If you compare with laws like Indian Penal Code, where we have 511 sections, this law is quite a small, this act or law is quite a small. But then there are too many concepts, so one need to give sufficient importance to this law. So I was explaining the chapters or structures. Chapter 1 dealing with preliminary. Chapter 2 deals with transfer of property by act of parties and general principles. Transfer of property by act of parties and general principles. This is covering from section number 5 to 53A. Remember, this is not applicable for Mohammedan law. Chapter 3, and also remember in chapter 2, 5 to 37 sections, section number 5 to 37 deals with immovable property. Chapter 3 deals with sales of immovable property. Section 5 to section 37 deals with movable property. So chapter 3 deals with sales of immovable property, 54 to 57. Chapter 4 deals with mortgage of immovable property and charges from section number 58 to 104. Chapter 5 deals with leases of immovable property from section number 105 to 117. Chapter number 6, a small chapter of 4 sections, 18, 19, 20 and 21, deals with exchanges. Then chapter number 7 deals from section number 122 to 129. Remember, section number 129 is not applicable for Mohammedan law. Chapter number 8, transfer of actionable claims, 130 to 137. Now, what is applicable for not applicable for Mohammedan law? I have repeated sufficient time by now. I hope you remember that. So let's move on to the next slide, which deals with chapter 1. Chapter 1, the preliminary chapter, which has section number 1 to 4. The major section under chapter 1 is section 3. And under section 3, we have 3 major definitions. So I am going to cover 3 major definitions with essentials and many other concepts pertaining to this particular aspects in this lecture, so that by the end of this lecture you will be prepared for these 3 major components of Transfer of Properties Act. What are the 3 definitions? One is movable and immovable property, second one is attested, and third one is notice. Let us understand what are these concepts in our next slide. One by one, I am starting with the movable and immovable property. The first one is movable property. The one is Transfer of Properties Act, which has sections from 5 to 37, not even have a definition for movable property. So it is not defined under Transfer of Properties Act that what is a movable property. So what should we do in that circumstances? We have to take the support of other laws. There are two major other laws which are giving definition of movable property, which are the General Clauses Act 1897 and Registration Act 1908. Now these two acts are giving definition for movable property. And what is the definition? Now if someone asks you what is truth, if you say truth is not the one which stays with lie, जो झूठ नहीं है वो सच है, that is the definition given in these two laws when it comes to movable property. Kind of similar scenario here. General Clauses Act 1897 and Registration Act 1908 say movable properties are those properties which are not immovable. That is the definition. So if something is not immovable, then that is movable. That is how they have defined movable property in General Clauses Act and Registration Act. So that looks quite vague, but don't worry, our lawmakers are not that easy. They have very clearly defined what is immovable property. They defined what is immovable property, and then they said what is movable property. Those which are not immovable property are movable property. So let us understand what is movable property to understand what is movable property. Let's move on to the next slide, which deals with immovable property. I have sufficient definitions for immovable property under the very Transfer of Properties Act section 3. Then I have Registration Act 1908 defines the immovable property. Then I also have General Clauses Act which defines the immovable property. Let's understand one by one. According to section 3 of Transfer of Properties Act, immovable property does not include standing timber, growing crops or grass. Now in the first sentence they are defining that what is not considered as immovable property. So the standing timber, growing crops or grass are not immovable property. So what is movable property? You can definitely take these three things, that is standing timbers, growing crops and grass are now movable property because they have very clearly defined they are not immovable property. Let's understand in a later stage that why are they not covered under immovable property. I will explain that. Let's continue with the definition. Thus, the term is defined in the Act by excluding certain things. Building constitutes immovable property and machinery, if embedded in the building for the beneficial use thereof, must be deemed to be a part of the building and the land on which the building is situated. Okay, now what and all concept they are bringing? Buildings they are bringing. The machineries which are embedded to building are also being covered, and then where the land used for such building is also covered. So we got three things under immovable property: the building, the embedded things and the land which is used. So these are covered under immovable property under this section. Now General Clauses Act section 3 subsection 26 defines all immovable property shall include land, benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. Please remember these keywords. We have heard this word now: attached to earth, fastened to earth, embedded to earth. We will also hear this word rooted to earth, fixtures. All these terms will come repeatedly, so we need to remember this. So the definition says land as well as benefits arising out of land. Now in the next slide we'll understand what are the benefits coming or arising out of land. So need not to worry too much on that as of now. Let's move on to the third definition, which is covered under the Registration Act 1908, which defines immovable property as: immovable property includes land, building, hereditary allowance, rights to ways, lights, ferries, fisheries, or any other benefit to arise out of land, and things attached to the earth or permanently fastened to anything which is attached to the earth, but not standing timber, growing crops, nor grass. Now the similarity between Registration Act 1908 and Transfer of Properties Act 1882 is both of them are saying standing timber, growing crops and grass are not immovable property. Let us understand these three concepts, why they are not immovable property. First, let's start with standing timber. What are standing timbers? Standing timbers are those trees which are nurtured just to take the wood for the purpose of furniture or for the purpose of building, construction and some commercial purpose, not for the purpose of growing fruits and other stuff. Now the very purpose of having such tree is to cut them and use it commercially in the later stage. So that is why they are always seen as movable property, because we cut so we can move anywhere. So the standing timbers will not come under the definition of immovable property. Now the second one, growing crops. Growing crops are embedded to earth, or they are connected to rooted to earth, not embedded to earth, they are rooted to earth. Like even timbers are rooted to earth for that matter. But why are they not covered under immovable property? Because the crops will cut, we will cut the crops in some time and then we sell it. So the very purpose of growing crops is to cut them. For example, we have a sugarcane field. Now after they come to grow to a certain extent, we cut them and we will sell them to sugar factory or sugarcane juice centers or the people who make jaggery. So we have different other things which we can make out of sugarcane, including taking molasses out of it for manufacturing of alcohol and other stuff. So there are different purpose we grow sugarcane for. Now after certain growth, we'll definitely cut them and move. So it is considered as movable property. The purpose is not to keep them till the time they are live or we get some fruits or flowers, nothing. It is for the purpose of cutting at particular time and selling it and get the money. So they move here and there everywhere. So that's why they are considered as movable property. Same with the grass also, we cut and use it at the later stage. So that is why the standing timber, growing crops and grass are never considered under immovable property. The following have been held as immovable property, that are they are a right to collect rent. Now we are coming slowly to the benefits arising out of land, that is rent, life interest in the income of the immovable property, a right of way, a ferry, fishery, a lease of land. Now lease of land is also benefit out of land. So all these are coming under immovable property. I hope by now you know which are covered under immovable property. In the next slide, I have also tried bring some images so that you will realize, remember those pictures in your mind, and while writing exams it will become easy for you to remember them and write which are immovable properties. Now we told many things, we repeatedly used land. Now let's understand what is land. When we are saying land, what and all we cover under land. The first thing, a determinate portion of earth is land. A determinate portion of earth is land. Now for example, the people who live in city, we usually ask how much land you have. They say I have one site with 30-40. So that is the determinate portion, that 30 by 40 is 1200 square feet, is the determinate portion of earth, that is the property, that is the land. The column of space above the surface, whatever 1200 square feet that they are telling, on that whatever is available, that is the property of the owner. The ground below the surface, whatever below is available under that 1200 square feet is the property of that particular land owner. Then objects under the surface like minerals, under, I think there is er missing there, spelling mistake, so please correct that by pencil and continue reading. Objects under the surface like minerals, if any mineral is available under such ground, under that 1200 square feet, that for that the owner of the land will become the owner. Then if there is any ponds, lakes, rivers, sorry, I have taken very small land for example. I don't think any ponds, lakes or rivers can be there in 1200 square feet, but if you have a big land and if you have ponds, lakes, rivers, you will be the owner of that property also. Then buildings, walls and fences on that earth, on that land will be of that owner. So land covers a determinate portion of earth, the column of space above the surface, the ground below the surface, objects and the surface like minerals, then the ponds, lakes, rivers and buildings, wall, fences, everything cover under land. Now benefits arising out of land. What are the benefits arising out of the land? Any benefit arising out of the immovable property and every interest in such property is regarded as immovable property. Then benefits such as right of way, hereditary allowance, lights, fisheries and ferries is also considered as benefits arising out of land. For example, you have a pond and then you have fishes in it, you do fisheries, or you are giving someone on rent basis to do fisheries and you are getting income for that, that is also called as benefit arising out of land, which is a immovable property. Then benefit arising out of land via mortgage also regarded as immovable property. If there is any mortgage happens and you get any income benefit arising out of it, then it is also called as immovable property. Now things attached to the land, there are 4 types of things attached to land. One is rooted to earth. What is rooted to earth? Trees are rooted to earth. Now the purpose of tree is very important to understand whether it is immovable or movable. Now if you are having a tree for the purpose of fruit, for example, the right extreme corner you see an apple tree. I don't know whether you are watching this video in mobile or computer, I don't know. It might look very small, but that's an apple tree basically. So if you are growing an apple tree, definitely the purpose of growing that tree is to get apples and sell apples. But if you are growing some timbers for the purpose of commercial use or making furniture, something like that, then it is definitely coming under movable property. It's very easy. You have an apple tree, mango tree or jackfruit tree, something else for the purpose of growing fruits, then it is a immovable property. The moment you want to cut it and sell it, the purpose is that, then it is movable property. Embedded in the earth. What are embedded in the earth? The buildings, walls, fences. Now they are embedded to earth. Attached to the items embedded in the earth. Now I told there are embedded to earth like buildings, walls and fences. If you have anything attached to that like doors or windows, they are coming under attached, because we are attaching those to the embedded properties. Sorry. So that will be considered as attached to items embedded in earth. The last one, chattel attached to earth or building, that is movable attached to immovable property, is also considered as things attached to the land. Oh, I was reading this things attached to the land, there is D missing. Correction can be done there. Now you see there are 4 images I have put just to help you remember in exam what are the immovable property. The first one is home with door and windows, very clear, you can see them. So the home is immovable property, and the doors and windows which are attached to the item embedded in earth, so they are also immovable property. The second image deals with fixtures. Now go to the corner where I have put one more box with one serial number 1 and 2. The serial number 1 deals with income raised out of immovable properties, also immovable property, that is rent, right of way, mortgage, ferry right, hereditary ferry rights, hereditary office, right to receive future benefits, future rents, future profit by land, revision in property release or leased, etc. are coming under income raised out of immovable property. Then I have also mentioned fixtures. What is fixtures? Light, fans, embedded machineries, doors, windows are fixtures. Now you see in the second image, you see a fan and there are lights which are embedded to the structures which are embedded to the earth. So these fixtures are also considered as immovable property. The third image, you can see the path and pond. These are also considered as immovable property. And then the last one, the apple tree. The purpose of having tree is for the purpose of taking fruits. Hence, it is considered as immovable property. Let's move on to the next slide. Keywords to be remembered. One is rooted to earth, majorly tree. Embedded to earth is building, wall, fence. Fastened to earth or attached to earth, then you have fixtures. Fastened or attached to earth, you can think of machineries. Fixtures, you can think of lights, fans and other stuffs. Now case law, I am referring to major case laws here. I am not going to tell too much about them. You have to read through because the video is getting little lengthier. Inox Air Products Limited versus Rati Ispat Limited, where things attached to earth or fastened to earth are immovable property. It was held in this case, Inox Air Products Limited versus Rati Ispat Limited. And there is one more case, Commissioner of Central Excise Ahmedabad versus Solid and Correct Engine Works. There the definition of immovable property was discussed again. Now in this slide, I try to bring the case of Marshall versus Green in the things attached to the land, number 1, rooted to earth. In this case, it was Marshall versus Green case. It was discussed and decided that tree as a art object is a movable property. Here a tree was used as art object, and it was decided in this case that in such cases the tree will be considered as movable property, because as I said in the very initial explanation itself, where if the purpose of the tree is to get fruits, then it becomes immovable property. If for any other commercial purpose, then it becomes movable property. In Marshall versus Green case, the tree was utilized as art object, so it is commercial purpose. Hence it was decided that such tree is a movable property. Now the second definition is attested. We have completed movable and immovable property. Attested meaning the signing of a document to signify that the attester is witness to the execution of the document. Now when you are studying, I'm sure if you have reached to the extent of law education, you have gone through many other colleges, scholarship or applying job, all other stages. When you do that, they will ask your marks card. Now everywhere you cannot give your SSLC, PUC, all other marks card. So what you do, you usually take copy of them and submit. Major offices will ask for attestation of those copies, because they need to be sure that these are the copies taken from the original. So what they will ask you to get it attested by the gazetted officer. Now when you go to the gazetted officer, he will see your original marks card and then attest your copy. So what is he doing? He is confirming that the copy is taken from the original. So that is the whole funda about attestation. Now in the law of Transfer of Property Act also, attestation is coming. So I have given a meaning of attested. Now essentials is discussed under the law. What are the essentials? The this must have signed attested either at the time or after seeing. Okay, it should be signed at the time or after seeing the properties related document only. The attestation should happen, and the document should be signed in the presence of executant. These are the two major essentials under attested. Now, who can attest? When you are discussing who can attest, more than who can attest, they are defining who cannot attest. A party can't be a attester. Now, if you are a party of, as I said in the very first slide, the transfer of property can happen between two living people. If that transfer of property is happening and you are one among that two living people, then you are the party to that transfer of property. So you cannot be the attester for that particular transaction. Second one, any interested party can't be an attester. Now, you are transferring property to Mr. X, and Mr. X's son want to be the attester to that transaction. Now, he cannot become the attester because he is the interested party of this transaction. So, any interested party cannot be the attester for transfer of property. Now, signing on behalf of an illiterate person is not attester. Now, if there is an illiterate person and somebody else would like to sign for the on behalf of illiterate person, that will not be considered as the attestation. If illiterate made mark by himself the description written by the scriber is the one who copies the document, then he is competent attesting witness. Now, if the illiterate makes some marks, then somebody else can attest for him based on the mark that he has made. Signature of the executant can be attested by an illiterate. Now, if somebody is the executant, then an illiterate can attest that, and then a person with power of attorney can't be a attester, as he is. It's very clear attested party, because in the power of attorney is given to take the responsibility of the transaction. So he is definitely part of the transaction. He is kind of agent, so he cannot do the attestation because he is interested party for that particular transaction. Now, what is the legal effect? Mere attestation does not show that attested has notice of consent. Now, whoever attested, by doing attestation, he is not giving the consent to the contents. That is what this line is saying. However, he can't deny the execution. He cannot say that execution has not happened. He should accept that, but he is, by just giving mere attestation, he will not become responsible for the notice, the contents that are in the notice. An attestation does not imply consent by itself. So that's the second fact. Now, I have referred to case laws. Please go through them to understand in detail. Kundan Lal versus Mushrafa Rafi Begum and Subramaniam versus Kropai Amal case. You have to refer for the case of attested. In Kundalal versus Mushrafa Rafi Begum case, Mushrafa Rafi was the attester, but then she told she couldn't see the executant because she was wearing burqa. But however, the court held that she could have seen if she had an intention to see. So that will not considered as not seen. So that was the judgment came in this case. Refer Subramaniam versus Krapai Ammal case for more details. Third major part is notice. The definition for notice is a person is said to have notice of a fact when he actually know that fact, or when, but for willful abstention. Abstention means an instance of declining, knows that fact, or but for willful abstention from an enquiry or search which he ought to have made, or gross negligence he would have known it. I'll repeat the definition. A person is said to have notice of a fact when he actually know that fact, or when, but for willful abstention, knows that fact, or when, but for willful abstention from an enquiry or search which he ought to have made, or gross negligence, he would have known it. So this is the definition of notice. The types of notice, there are two major types of notice: expressed, which is also called as actual notice, then there is implied or constructive notice. Express notice, definite information given by the interested person or notice is issued is expressed or actual notice. Here the party interested will give the definite information or serve a notice, which is called expressed or actual. The second one, implied or constructive. Here a man who ought to have knowledge of a fact treated as if he is actually knows it. There is a case of Manchand versus Chandravati, where a person is buying a home from tenant. Then later it was proven that the tenant was not the owner, he was just a tenant and he had no ownership to sell it to someone. But the buyer should have inquired about the interest of the tenant first and then gone for the purchase. So that is implied or constructive notice that one is having. There are 5 classes of constructive notices. I have given them in detail. You have to refer cases or the facts that I have mentioned in these. The first one is willful abstention from an enquiry or search amount to notice. Considering that one had struck a good bargain and to ensure that no one else buys it, dealing in hurry amounts to willful abstention. Now you are seeing a property and you feel like that is worth of some 30 lakh rupees, but the owner of the land for some reason sells it to 15 lakh rupees, or he is ready to sell for 15 lakh rupees. You are not inquiring in detail that why he is selling it for 15 lakh. You just make the payment and buy it at the earliest, just to ensure that you are not missing the land or somebody else will buy that land before you buy it. So now that will not be considered as the correct practice, because that's willful, that will come under willful abstention from an enquiry. You could have enquired it in a better way to understand the reason and then gone for a purchase, but you have not done that in a hurry to get a benefit out of it, so that will not be considered. Now the second one, gross negligence may amount to notice. Now with applying your care, skill and diligence, if you could have find some facts and avoided any transfer of property going negative way for you, then it will be considered as constructive notice only. There is a case of Mahadev Keshava Lingarkar versus Shamrao Balwant Kesarkar, where it was held that he had an opportunity to know about the notice, but he didn't took the chance of or he didn't apply sufficient care, skill and diligence to understand the notice status. So that is coming under gross negligence, and that will not secure you in any ways. That notice itself is considered as constructive notice. Registration as a notice, there is a case law KLV Prasad Rao versus Venkateshwara Gaud, where sale deed were registered and that shall be considered as notice. This is held in the court. And there is one more case, Tilakadri versus Kedanlal. Circumstances of each case is to be considered to decide whether the registration of document acts as a constructive notice as to the contents in the document. Now they have said each cases need to be seen separately and decided whether registration is considered as a constructive notice or not. Now I am giving an example. A mortgage his property to B, B submortgage it to C. A is ignorance of the submortgage pays submortgage and pays the mortgage debt to B. Now though the submortgage registered, it does not amount to notice to A. Now A, he has mortgaged earlier with B and B then submortgaged it to C. Now A is not aware that there was a registration between B and C and he pays the mortgage to B. Now B cannot say there was a registration happened and that becomes the constructive notice. There is a chance of argument. Then possession as a notice. Now there is a case law case study I am giving. Ram contract to sell property to Beam for rupees 10 lakhs. Ram has a property and he contracts with Beam for rupees 10 lakh. After selling this to Bhim, he again sells the same property to Sham for 12 lakhs. Now, Bhim is staying in that house. Sham comes to Ram and asks whether he is interested to sell the property. Ram says yes, he will sell the property. He is selling the same property again to Sham for 12 lakh rupees. He has sold earlier this to Bhim and he is making a second transaction out of that property by selling the same property to Sham for 12 lakh. Now, Sham had all chance to inquire with Beam before he had this transaction, because Beam is staying in the house. He could have definitely asked, why are you staying here? What is your interest? This word interest I am repeating because this is one of the major words used under this law, and in my future session I will clarify what is interest. Now, he could have definitely asked Beam that why is he staying here? To what extent his interest is there in the home? But he doesn't do anything like that. He just go to Ram and buys the property for 12 lakhs. Now, Beam's possession of the property itself sufficient notice to Sham. Hence, Sham can't claim specific performance. Now, as Beam is staying in the home, he has the possession, that itself gives a sufficient notice to Sham, and Sham should take sufficient care accordingly. Now, notice to the agent. Knowledge of the agent is knowledge of the owner. Notice to an agent. The knowledge of the agent. Yeah, my son is here. Say what you want to say to everyone. Hi everyone.
Hi everyone.
Yeah.
Subscribe my father's channel.
Oh. Okay, please subscribe my channel. So I will continue this session. You can leave. I am almost done with this lecture. Yeah. I was dealing with notice to agent. Little distraction with my little kiddo, Nishan. If you want to watch him more, I have few videos of his also. You can show it to your kids. So, or if you are a student, you cannot show it to your kids because you are still a collegian. But then, if you have any kids, you can show his videos. Notice to agent. When agent is having notice, it is considered that the knowledge is available to the principal also. So knowledge of an agent is knowledge of an owner. So that's very important fact that you need to remember. That's with this lecture. I will quickly take you through the entire series once again before we conclude, so that you can remember the chapters, the details, applicability and other stuffs, and you can apply accordingly. This is just a brief in the next 2 minutes. First, we started with the introduction, date of effect from 1st July 1882. This is submitted by the Third Law Commission, 3 British people, that is Sir Charles Turner, Sir Raymond West and Mr. Whiteley Stokes. Then you have to refer this act with Succession Act, Contract Act, Sales of Goods Act, just to understand the concept very clearly. Then when we were discussing about scope, there are 5 scopes: within India, within 2 living people, transfer of property between parties only. Then this mostly deals with immovable property. Then chapter 2 and section 129 not applicable to Mohammedan law. Applicability we have discussed: applicable for sale, mortgage, gift, exchange and charge; not applicable for inheritance, insolvency, forfeiture, sales of execution of decree and by will. Next, we discussed about the 8 chapters with section number 1 to section number 137. Then we discussed the 3 major definitions, that is movable and immovable property, attested and notice. Movable definition is not available, but however immovable definition is available under General Clauses Act and Registration Act. On the basis of that, we have arrived what is movable property. Then we have seen the definitions under Transfer of Properties Act for immovable property. Then we have seen General Clauses Act as well as Registration Act, which have defined very clearly on immovable property. Further, we have seen immovable property, what is land, benefits arising out of land and things attached to the land we have seen, and then we have seen the key words and case laws pertaining to immovable property. We have also understood attestation, attested, meaning, essentials, who can attest, and legal effect of attest, that we have seen. Then we have studied the notice part. We have seen the definition, types of notice, major types, expressed or actual, and implied or constructive. Then we saw 5 classes of constructive notice or implied notice, which is willful abstention, gross negligence, registration as a notice, possession as a notice, notice to agent. I hope this session helps you to a greater extent. I'm coming up with more videos in my next section on this particular subject. Please subscribe me. Please share this video among your friends. Please support me by that way. Encourage for more videos. Thank you so much for watching this. Take care and all the very best for your exams. Thank you.